Attendees are in listen-only mode.
Good morning, everybody. I'd like to welcome you to this morning's webinar on the Construction Design and Management Regulations, or CDM Regulations, and it's with regard to the proposed changes for 2015. My name is Katie. I'll be looking after you this morning. I'll be here to answer any questions that you have throughout the event. And during the course of the webinar, we intend that you will learn what the proposed changes are, how the CDM regulations will actually affect you in what you do, and when these changes are actually likely to take effect. This morning you have the option to raise your virtual hand to ask a question, which will be on your dashboard, which normally is on the right hand side of your screen, or there is actually the facility to type your comments and questions throughout. So if you have any questions as we're going along, pop them into the question box, and again we'll be able to answer them as we go along. We've also got a Twitter hashtag this morning, hashtag CBuildECPD, which you can contact us on. I shall hand you over to your presenter, who is Kevin Blunden. He's our Deputy Chief Executive on the technical elements of the industry, and he'll be looking after you. So I will hand you over.
Good morning. There's usually a slight pause while things move and change between Katie and myself. But welcome to this webinar this morning on the CDM regulations, which are changing. The proposed changes will come into effect next year on the 6th of April. And perhaps before we start looking in detail at the changes, perhaps it's worthwhile just looking at the context and setting the scene as we've moved through CDM regulations in the UK over the last 20 years or so. So CDM has been with us in a regulatory format since 1994, for 20 years now, and they are largely as a result of the UK trying to meet its obligations with the European Union to meet some of the European directives aimed at reducing health and safety issues during construction projects and in the use of buildings after completion. In 1994, the regulations were introduced to attempt to improve the ways in which health and safety were considered, and to include in the design and construction phases the ability to examine the implications of the design in terms of safe buildability and the continued safety in the operation and maintenance of the building. When the regulations were introduced, they introduced the role of a planning supervisor, and it was anticipated at that time that that role, although it was a named function, would actually be carried out by someone already in the design team carrying out another role, such as the designer or the contractor or one of the other professionals involved in the role. It wasn't really envisaged when the regulations were brought in that it would evolve into an entirely new profession. By 2007, the process was being seen as too complicated and focused on bureaucracy and form filling rather than the outcome of the safety in the design and the construction. And at that stage, the planning supervisor morphed into what we now know as a CDM coordinator. And whilst the safety records in the industry did continue to improve, the change wasn't as significant as had been hoped. And in the UK, we were still failing to meet some of the European directive, and particularly in two key areas. The directive wanted the legislation to apply to all projects, whereas in the UK we had excluded the domestic sector, and the thresholds for when the proposals came into effect was also slightly different in the UK. And the original European directive's intention was that whenever you had more than one party involved, more than one contractor, there was a need to coordinate and move it forward. Sorry about that, the slides seem to have skipped back a bit. So, we've been through a consultation process on what the regulations should contain, and the industry was asked its views on some draft regulations put forward by the Health and Safety Executive, and the Health and Safety Executive got, as a result of that consultation, 1,427 responses, which as far as public consultations are concerned seems to be an incredibly good number and a good basis to move forward on in terms of what the industry thought of the proposals. However, the 1427 might not have been as significant as we originally thought. 400 of those responses were a concerted effort from the entertainment industry to try and ensure that the CDM regulations didn't apply to temporary structures that are often put up in relation to sporting events, festivals, entertainment, outdoor events and the like. That basically caused two things to happen. First of all, the HSE decided that as this was a concerted campaign that wasn't really focused totally on the content of the regulations, they would largely discount those responses and those comments. But it has also prompted the Health and Safety Executive to talk directly to the entertainment industry to try to establish how we can deal with safety in that sector. There was another large group of responses, 524, that came from practicing CDM coordinators. Now, the proposals put forward by the Health and Safety Executive clearly made it the intention that the role of a CDM coordinator would not exist in its own right defined in the legislation. So they took the view that these 524 responses, because they came from people practicing that role who in effect job was at jeopardy, they also wouldn't necessarily give as much credence to those responses. So that left us with 503 responses from across the industry. And that's relatively low if you look at the number of registered architects, other professionals such as fire engineers, structural engineers, service engineers who would build into the design, let alone the contracting side. That is an incredibly small percentage to move forward on. Having said that, the Health and Safety Executive did take some comfort that most of the professional bodies in the industry who responded broadly supported the proposals that were put forward in the consultation. So we've moved forward with a format of what we're expecting to see. So now, during this webinar, we're going to ask you a few quick questions to try and get a better understanding of where you sit, where the focus of the industry is, and how things are actually working. So this first question, I'm going to ask you what your role is in relation to the current CDM regulations. So the question has a few options for you to choose, and what I'm asking you to do is to pick the one that you mainly undertake. So just give me 1 second whilst I get the correct poll there, and now you should be able to see a choice of options on your screen in relation to which role you actually undertake. And if you could indicate there which of those is your current main role, then once we've had a chance for everybody to vote, I'll share those results with you to get an idea of where the audience today sits, and it also helps us as an association to understand what our members are doing. Right, you're all happily clicking away. I've got to the stage where nearly 90% of you have voted now. So just a few more minutes on this poll. Okay, we're more or less there, so I'll close that poll off. Okay, and some quite interesting results there. I'll pop those up so that you can have a look at them. As far as our audience is concerned today, we've got a fairly even split between CDM coordinators and designers, a reasonable showing for clients, very few contractors with us today, and 41% of you who aren't directly involved in any of those roles, but obviously need to know as professionals in the industry what's going on in relation to CDM regulations and how it might affect you. Okay, so moving on, hopefully you've now bounced back and can see me again. I'm sure if you can't, Katie will let me know shortly. So yes, that gives us an idea of where we sit. It does also mean that certainly for today I don't have to worry too much about focusing on the contractor side of the proposed changes, which actually is quite useful because in real terms the responsibilities on most contractors hasn't changed, although as we'll see there is a difference in the domestic market. So the current CDM regulations set out some overarching duties and responsibilities on those involved in the projects. And then they established some criteria for notification of projects to the Health and Safety Executive. And that notification also triggers some additional duties. Much of the arrangements under the CDM 2007 regulations revolve around this coordination and communication role, which is currently the responsibility of the CDM coordinator. And when it was introduced, it was hoped that the role would become an integrated part of the design team, able to affect and influence decisions that related to health and safety. That's not been seen as being fully achieved, and they're now seeking to take the duties that were allocated to the CDM coordinator in the 2007 regulations and pass them on to other people already embedded in the project team, hopefully removing a level of complexity and making sure that the health and safety is embedded throughout the process. That having been said, it will obviously require certain other parties, particularly the designer and the contractor, to take on additional duties and roles, and it may mean that the client has greater responsibility than they thought for before. So the notification to the health and safety executive is quite a fundamental part of the CDM regulations. And in trying to simplify matters, the 2015 regulations have tried to divorce the notification process from that of the duties. So the duties and responsibilities under the CDM regulations will apply to all projects, whereas only some projects will require notification to the health and safety executive. In looking at what requires notification, we're not only looking at the length and the duration of the project, but we're talking about the number of people who may actually be engaged in the project on site. So there is a subtle difference between 2007's notification and 2015, in that we are looking at a project that lasts more than 30 days on site and has more than 20 people on site, or something that's more than 500 person days. So the 500 person days could potentially be something like the DIY big build, where there are 100 people on site for a week. In adding in the more than 20 odd people on site, it has changed the scope of the notification. We have also at the same time changed some of the background regulation so that actually this notification now applies to domestic projects as well as commercial projects. In reality, what this may well do is take out of the notification project process some of the smaller projects. In the past, if the project was going to last more than 30 days on a small commercial project, it didn't matter how many people were there. Once it lasted 31 days, it required a notification. Now there have to be 20 people on site. And that means that some of those smaller projects will come outside of the notification regime. Whilst that means that there's no longer a need for an F10 form to be completed and submitted to the Health and Safety Executive, and perhaps reduces some of the bureaucracy, it does seem a little odd with certain parts of the industry. We know that as a track record, the issue with health and safety on site is quite significant on the small and medium-sized construction projects. And it's actually these projects that may be taken out of the notification arena by this proposal, which actually means that the health and safety executive won't be aware of these projects in advance and really will only be dealing with them when something goes wrong. So I'm going to ask you now, if you are involved with the project, and I appreciate you're not all involved from a CDM coordinator or designer point of view, but if you're visiting a project for any reason, what I'm asking now is, how many of the projects you're involved with do you think would require notification under the current rules? So last more than 30 days or have more than 500 people on in terms of people days. So under the current rules, I'm going to ask the question again in a moment under the proposed rules to see what the change is. How many do you feel, what percentage of projects do you feel are actually within the current rules for notification? So I've opened the poll there and you've got basically a scale in terms of the percentage of the projects. Okay, and once again we're quite happily voting along. I've got a little bar chart flashing in front of me to give me an indication of the relative percentages. Although I must admit some of the scope seems to be we're getting there. Good. Right. Okay, I'm just about to close the poll. Time for the last few votes. As with anything, we always tend to find that actually there's a percentage of people listening today who don't vote, but that doesn't necessarily matter. I think on a proportional basis the results are pretty much the same. So let me share those results with you. So there we can see that roughly a third of the projects out there, we're saying over 75, so a third of you are saying over 75% of the projects would require notification. Then it sort of peaks again at the less than 25, and the bit in the middle is a sort of a trough. And very few projects at the bottom are actually saying none. So that's quite interesting. Now what I want to see is if this actually changes. So if we go back and move on a slide, hopefully. Taking a little while for the slides to catch up. Now that doesn't want to move. Right, okay, hang on. So, same question again, but under the new rules. So now including in the 20 people on the sites. So if I could ask you to answer the same question again, just so that we can look at a sort of a comparative answer. Okay. Right. So again, if I share those results with you, this time round, what we seem to have noticed is that the top end has dropped down, whereas the less than 25% seems to have significantly increased. So that would appear to indicate that under the proposals we are expecting fewer jobs to actually be notified. Right, okay, and I'm back in the room. Okay, at that point I think I'll just ask Katie if we've had any questions yet that we could perhaps deal with.
Hello. It's fairly quiet on the question front. Just Michael just querying, saying, isn't it more than 20 people on site at all times?
Yes. It's not a question. Sorry. The answer to that one is not just 20 people on one particular day. It's intended to be 20 people for the 30 days. So it does make it quite, or not as onerous in terms of notification. Okay. If we haven't got a lot of other questions, then we'll crash on.
No, you can move on, Kevin. That's fine.
Okay. All right. So looking at when the one of the areas that we were failing to meet our objectives under the UU directive, it was in relation to when the regulations applied, and the main principle needed coordination whenever there was more than one party involved. So as soon as there were two contractors, there was an element of coordination needed. And one of the key changes in the 2015 regulations is that the duties for coordination to ensure health and safety will kick in on all projects regardless of whether they require the F10 notification to the health and safety executive or not. And the regulations now place further obligations on all of those involved in the project, including domestic clients. Now, interestingly enough, it has been recognized that your normal domestic client, householder, will not understand the complexities of the regulations and will not understand what their duties are. So there's a sort of a default for domestic clients that their duties automatically pass to the main contractor, and we'll look at the implications of that in a moment. But otherwise now we're looking at all projects, anywhere where we've got contractors involved, and a clear distinction between the principal designer having the main role during the pre-construction phase and the principal contractor during the construction phase. This does, however, raise the question of what actually happens during the construction phase when design changes occur. Most projects need an element of design during the construction phase, and a lot of what are now being termed sub-designers, but we would see as specialists like the M&E consultants, the structural engineer, the fire engineer, may not be on board until work is actually on site and their element of design is being done at that stage. Now, the principal designer will be coordinating their work, but obviously the main responsibility for the health and safety is under the principal contractor once we're on site. So the scope has changed, and to change the scope, what's been done in the proposed regulations is to tinker with the definition of a client. Under the 2007 regulations, a client who was someone having a project carried out in the furtherance of their business. A client now is basically anybody who a project's carried out for, and then a domestic client is further defined as somebody who's having work carried out that's not in the furtherance of a business. And that is because within the regulations there are allowances for domestic clients in terms of who's responsible for what. So we've taken away the all-encompassing definition and tweaked that. We've changed the definition slightly, and it does mean that in some cases the client now will transfer some of their duties to the contractor in the domestic sector. It is also important to understand that under the proposed regulations, whereas in the past it would have been the CDM coordinator who usually ensured that notification had gone off to the health and safety executive, it's the client's main responsibility to make sure that that is done in this case. And we would expect that as soon as the client appoints a professional to assist them, be it a designer, a contractor, or what have you, that they would advise the client that that's the case. So in terms of the client's responsibility, they do differ depending on whether it's a domestic or a non-domestic client. In the domestic sector, as I've said, there's an exception that the client will not have, an expectation perhaps, that the client will not have sufficient knowledge to discharge all of their duties under the legislation. And therefore, their duties pass by default to the principal contractor. Having said that, they could still appoint a principal designer, and he would take on that duties. But it's not an automatic case that the designer that the client engages becomes a principal designer and takes on the role of the client's duties. They will still have their own duties, they won't take on the client's duties. In the non-domestic sector, the client will take on a principal designer and a principal contractor, and they will then take on those roles. If the client doesn't engage a principal designer or a principal contractor, then the client is considered to be carrying out those roles. So there will still be the option for clients, both in the domestic and the non-domestic sector, to decide that for this project they don't want to carry out all of their duties themselves, and that they would rather have a third party do that for them. So they will still be able to appoint or contractually employ someone to carry out most of their role. That person would be the CDM coordinator, or the role that we know as CDM coordinator now. They would still be able to offer services to the clients, they would be able to assist the client in making sure that they carry out their duties, and contractually deal with issues of communication and coordination. There will still be a legal responsibility on the client, but it is foreseen within the industry that particularly at the more complicated end of the projects, the larger jobs, that individuals will still be employing a separate professional to carry out this role. In the smaller and medium-sized jobs, that role will probably be absorbed into the designer and contractor role. Okay, I think that's now causing a little bit more consternation amongst the audience. So Katie, have we got any more questions at this point?
Hello. There's a few coming in, a couple which appear to be similar. Got a question of, if there's less than 20 on site but the project is longer than 30 days, would registration be required? How about that?
If it's less than 20 on site and it goes on for more than 30 days, no. The issue is that it's 30 days and 20 on site. So no, under the current proposals, no. Now, one of the issues that we'll touch on in a moment is that there isn't intended at this stage to be a full and comprehensive guidance or code of practice to go alongside this. So as with any change in legislation, really until somebody tests the boundaries and we get a series of case law, you don't really know what was intended in terms of interpretation and what the output was intended to be. I think the Health and Safety Executive will be doing a fairly large education exercise, but the concept here is that there will be a lot of projects taken out of the notification stage, and we probably won't be seeing associated guidance to explain how this is going to work for maybe 6-9 months after the regulations come into effect.
On a note on them coming into effect, do you know when they're actually going to be taking place, the changes?
Yeah, I will be covering it off later on,
that.
but the intention is that the regulations will come in on the 6th of April next year, but I will talk in a little while about how the sort of changeover is anticipated to occur. Okay. Is there anything else, Katie?
Yes, they're coming in thick and fast, actually. So, Michael is asking, how does a domestic client know that the principal contractor is appropriate to undertake the function, and can the architect or agent be the principal designer?
Yeah, again, something that is detailed in the current regulations and the guidance that doesn't really get addressed going forward is the issue of the competence of the individuals involved. And there is an emphasis on the client to appoint competent people to carry out their role. Now, yes, a domestic client won't necessarily have the knowledge or the understanding or even be aware of the regulations to the extent that they need to make sure that the contractor is competent. They also, to be perfectly honest, it's a case that most contractors in the small and medium sector may not be aware of what obligations they're taking on either. The client could choose to make the designer, the architect, whoever's prepared their plans for them, a principal designer and take on some of the responsibilities. And they could obviously contractually ask that principal designer to do some of the coordination role in the same way that they may engage a separate individual to do the CDM coordination. But legally, there are these defined roles in relation to projects. And as far as a domestic client is concerned, the duties by default go to the contractor on the hope that they've got slightly more knowledge than the client may have. Okay, anything else?
To be honest, Kevin, like I said, they're coming in really quickly at the moment. If you continue, and a note to anybody who is asking questions, that if we don't actually answer your question during the course of this webinar, we will reply to you actually after the event. So we will
carry on, because yeah, if I carry on, it may address some of the issues anyway, and certainly we'll have plenty of time to include questions at the end. Okay, going backwards. Right, so on large complicated projects where there's an extensive design team, it is anticipated by the Health and Safety Executive and by most of the industry that the client will still choose to appoint someone to act on their behalf to ensure notifications are done and that all the parties are communicating and that everything's well coordinated. So although there is no defined role in the regulations under the 2015 changes, it is anticipated that there will be a large number of projects that will still have somebody doing the coordinator's role. But with the defined role disappearing and no clear guidance on the correct level of qualification or experience for somebody to carry out that role, there will be a greater emphasis on the client to make sure they're getting the right quality of service. And normally during the construction process, the first person to be appointed will be the designer. So the client will probably lean quite heavily on the designer for advice about what they should be doing. So it's important that the designer not only understands what their obligations are, but can advise the client effectively. The problem is on the small and medium-sized projects, and it's quite possible that the additional cost in engaging the services of a separate CDM coordinator will mean that it will disappear from the process. Now, the client may well look to get the same sort of service from the other professionals involved, so from some of the designers, some of the contractors. But it's a fairly odds-on certainty that they won't want to pay any additional fees for those individuals to carry out those roles. So in terms of the principal designer and their role, in any given project there will be a number of designers who contribute to the final finished design. The principal designer is usually the one who brings all of that information together and formulates it into the overall project. But it could just as easily be on a first into the process basis. So if we haven't necessarily got a principal designer, but we've got a range of designers working together, the first designer appointed may by default become the principal designer. And the principal designer then has the responsibility to plan, manage, monitor and coordinate the pre-construction phase. They also have to, as far as reasonably practicable, ensure the project is carried out without risk to health and safety. They are responsible for preparing and updating the health and safety file, And one of the slight quirks in the proposed legislation, I'm sure they'll button up before it comes in, is that there's no end date to maintaining that health and safety file at the moment. So even post-completion, as the legislation stands, there's still a requirement on the designer to carry on updating that file throughout the life of the property. I can't really see that working in a contractual arrangement. The other thing the principal designer has to do is ensure that the other designers comply with their duties. Now, as it's written into the legislation, they have the legal responsibility to ensure that others comply with their duties. In practical terms, they will not have the contractual arrangement to be able to make sure that happens. So that's very onerous on the designer, and I'm not quite sure, again, how that would have been enforced through the courts should it need to be. But it does mean there's some very interesting conversations to be held with the insurance industry in relation to the designer's policies and their liability, taking this new role into account. And as I've said, there is a major issue as to whether or not the client is going to pay the designer anymore for carrying out this service. So who counts as a designer? It really is anybody in the process who inputs into the design. So it's very broad, and it will include most of the professionals and some of the contractors who are doing design and install type elements. It can even include individuals like town planners and conservation officers. Now, as with the current regulations, the designer and the definition specifically includes those carrying out a statutory role, such as building control. So if building control advise on a design in relation to building regulations, they are not considered to be designers under the legislation. However, just a word of caution for those of you who may be operating in that field, that relates to the statutory function. If you provide advice over and above the statutory requirements, then it may well be that you do then fall within the scope of being a designer and take on some of that responsibility. In terms of the principal contractor, they take responsibility once the work starts on site during the construction phase. They manage the construction process, the health, safety, the welfare facilities on site. They coordinate the subcontractors, and they monitor the works as well. They will also collate all of the information that needs to go into the health and safety file and pass it back to the principal designer. And as I've said, on the domestic projects, the principal contractor will take on the responsibility of the client, including the notification where it's necessary. Other than on domestic projects, the broad intention of the 2015 regulations is that the role of the principal contractor will not significantly change. All that we'll see is where it previously said they liaise and work with the CDM coordinator, it's now working with the principal designer and the other parties in the process. So, quick question about how health and safety is currently dealt with on site, and this is more to make sure that you're actually still awake and listening, even though you may be hopefully tucking into a bacon roll or something of the like. So how do we actually deal with health and safety on site at the moment? Do the contractors, in managing the site circumstances, carry out site inductions when people turn out on site? Do they ask to see CSCS cards? Are they quite happy that somebody who's a professional working in the sector actually has sufficient knowledge to be safe on their site? So how do we actually, or what's the perception of how safety is dealt with on a day-to-day, on a site basis? So you've got a quick poll in front of you now asking whether you are asked for a CSCS card, whether sites carry out inductions, whether that's all of the time, some of the time, or whether actually very, very rarely.
Kevin, can I just ask, sorry to interrupt, does this refer to domestic or non-domestic?
This would be, at the moment, it would be non-domestic projects.
Thank you.
Primarily, because we don't tend to see this format in the domestic because it's outside the scope of the regulations at the moment. This will be interesting information because I'll feed this back to the Construction Industry Council's Health and Safety Committee to try and get an idea and balance the perception of how it's actually being dealt with. Okay, so we're up to over 3/4 of you have voted now. Okay, right, we'll close that one and I'll let you see the results of that. So I suppose looking at that, the bad news is for the people operating the CSCS card scheme, the Construction Industry Training Board, because it would appear that very few people ever asked to see a CSCS card. There's a reasonable degree of sites carrying out site inductions, but also quite a high, a third of the jobs probably aren't asking to see anything. And that, I think, probably reflects where we thought the industry was. And I would guess, although there wasn't sufficient options in the question, that most of the jobs carrying out a site induction are probably the larger projects. But clearly, there's probably an assumption behind this, that guessing that most of my audience today are professionals working in the industry, that if you are a professional, you've got a reasonable level of understanding. And that actually reflects some of the proposals going forward, in that the industry is lobbying hard to say that actually qualified professionals shouldn't have to go through the online health and safety test and obtain a CSCS card. Their professional qualification should demonstrate that they have a base knowledge in relation to health and safety. So I mentioned briefly earlier that the guidance was going to change in terms of the regulations. At the moment, we have what's termed an approved code of practice. That approved code of practice has a significant legal status and can be used to demonstrate the regulations have been addressed. That has, under the current framework, been supplemented by some industry-produced guidance, particularly focusing on the roles of the individuals, like the designer. And across the board with all legislation, the intention from government is to reduce the amount of government-produced guidance and have it replaced with industry-led. And that's the same in this intention with the proposals under CDM. The proposals and the framework of the regulations was actually such that the intention was not to provide a code of practice at all to accompany these regulations. That, during the consultation phase, was queried by most of the people who were responded, and so it has been decided going forward that there will be a smaller, much reduced guidance document, but all it will really do is signpost the industry to other sources of information. But at the same time, the industry is producing some targeted guidance, and this time round the targeted industry guidance will be not focusing on the individual, but focusing on the type of project. So we're expecting to see some guidance come out to deal with domestic extensions and with smaller projects like shop works and stuff like that. So it will be more targeted, relating to the type of project. One of the big issues with the code of practice was, the approved code of practice, was that in an appendices it did give some significant guidance on what made somebody competent to deal with the roles they were to carry out, particularly the role of CDM coordinator. It did detail what sort of knowledge they needed to have, and in removing it, they are looking to widen the scope of what people can consider to achieve competence. Now, although the document and the code of practice exist at the moment, as soon as the new regulations come in on the 6th of April, that document will cease to have its legal status. So we won't be able to use that as a guide going forward. I am absolutely sure parts of the industry will still use some of that as a guide, but its legal status will have changed. Because there was no real immediate intention at the consultation phase to provide a new code of practice, although they are now working on this smaller signposting guidance, that won't be ready when the new regulations come in, and it will be some months after that that the actual code of practice will come in. That being said, the industry is already ahead of the game on some of the targeted guidance, and it is hoped that that will be available in April when the regulations change. So we will have this smaller guide, but it won't deal with the issue of competence of those involved, which does mean we're left with a bit of a hole, or in fact a series of holes, when the guidance disappears. There won't be a code of practice in place for a significant period after the regulation comes in, which will mean we will have a bit of a gap. What I expect is that the professional bodies, probably together on a combined approach, will give some guidance to their members to cover this hole, maybe. The industry-led guidance will be just that. It will be guidance. It won't have a legal status. There'll be no obligation to follow that guidance. And the big focus here, the big change, is on the smaller projects to get the contractors, the designers, and to a certain extent the public and the clients aware of what they need to be doing. Taking out the guidance on competence does, on one hand, recognise that most qualified professionals working in the sector should be capable of fulfilling a role. But on the other hand, takes away that guidance to the client that has up until now guided them in relation to appointing the right people into the roles. So, when is all this going to happen? Well, post-consultation, the proposals have been published. We are expecting some slight tweaks to those proposals shortly. With the general election looming, there's an awful lot of legislation trying to go through Parliament at the moment. But there is a clear determination for this regulation to go through so that we can instigate them on the 6th of April. And that is because, as I said earlier on, at the moment we are in default in relation to the EU directive, which could end up having a penalty effect on the UK. So there is no doubt that this legislation will move forward. We've then got to look at how we change over. If we've got a project that starts today and we appoint a CDM coordinator, but we know it's going to last for 12 or 18 months, what happens on the 6th of April? Do we suddenly change everybody's roles in that process? Or do we actually then just say, okay, we'll just see how we go and carry on as we go? The proposals are that where we started with a CDM coordinator, we carry on through the project with their process. That's quite clear where the process is already on site. It's maybe not quite as clear where we're looking at a project that's in concept stage or very early stages of design. And I think there it's anticipated that we'll take the new proposals forward as we go. Okay, so there are some transitional arrangements in relation to the regulations. They will be firmed up as we get there. Right, I think at that stage that's what I was intending to say. So now, Katie, have we got any further questions?
Hello. You have covered off a lot of the questions that have come in. So for in example, the guidance being open for interpretation and the fact that there isn't a code of practice in place, that's kind of a common theme for questions. There's also, again, a common theme has been about the projects spanning over the 2 periods, which I know you have just covered, and also a lot of conversation about CSCS cards and whether they're actually required, and obviously that comes down to difference of opinion, but an interesting discussion.
I think with the CSCS cards, I think the critical thing there is are you safe when you go to site? As a professional visiting the site, if you are left to wander the site unaccompanied, then it's absolutely critical you get a sort of day-to-day induction just to tell you, oh, there's a hole over there or that scaffold's incomplete when you get to the site. But the majority of professionals, when they visit the site, actually get accompanied around by somebody who's trying to guide them at the right things to look at maybe and avoid some of the other bits. But it's really the contractor's issue to manage, and if they can deal with it by accompanying people around the site rather than asking for a card, fine. As I said, there is a growing body of opinion in the industry that we recognise that most professionals don't need to undertake a separate test. Now, what is critical to getting that recognised by the powers that be is to make sure that within all of the qualifications that lead to somebody being professional, there is relevant information about health and safety. Okay. Anything else?
I've got a question that's just come in, actually. I'm just reading it, and it says about, is there anything from a colleague who works in education about that can be sort of told to students about the changes? Any sort of straightforward, I suppose, nuts and bolts guidance as to how this is going to go forward?
Well, the first thing I would say to that, and as you will probably say in a moment, is that this webinar will be available on our website, so people can always look at what I've said here. If you want it more from the horse's mouth, there is some basic information on the Health and Safety Executive's website, but at the moment, because the regulations haven't actually gone through, it's not fundamental and detailed. There's draft regulations there, but there isn't a lot of explanation behind it maybe. But what we will see certainly over the next 6 months across the industry will be a whole raft of information coming out of the industry to guide people on their roles. There are two groups that are producing most of the information at the moment. There's a group called CONIAC, C-O-N-I-A-C. They are working on producing the guidance. That's a cross-industry body dealing with health and safety. And there's also the Construction Industry Council Health and Safety Committee. Both of those bodies will be putting out information over the next few months. And particularly, I think, in terms of those in the education stream, some of the targeted guidance will be on the right pitch at the right sort of level for student entry into the industry to give an overview of the regulations. Okay.
Okay, again, Kevin, there's a lot of questions coming in with about the 20 people in 30 days. I think what we'll do after this event is we'll put together another sort of FAQ document and have that available online, because there's a lot of questions sort of asking similar things. So we'll put something together and we'll make that available as well. I think that's probably the easiest way to cover off a lot, because a lot of the questions that are coming in are referring to specific examples.
Okay. What I will do then is when we close down this webinar, I'll take all of the questions away, and as far as possible then look to address all of those individually, or where the questions are the same en masse, and we will, as Katie says, we will post all of that on our website for people to have a look at. And if there are any specific cases that are relating to individual projects, then obviously we have your contact details. I'll get in touch and talk to you direct about those. Okay. Is that more or less the gist of it then, Katie?
It is, yes. Hello. Yes, mainly, like I say, we'll put together a document. I just want to address one question that popped up with regard to your polls, because obviously the responses are as a percentage. And I've been questioned on how many people are actually online this morning. We've actually reached 86 people have actually dialed in this morning to join us and to attend. So in terms of the percentages, and the polls were receiving a sort of 93 to 95% response rate. So that gives you a sort of an indication of the responses.
Yeah, so it's the high 70s, and I think the important thing from my point of view is actually the question that didn't necessarily seem to relate to health and safety, which was about which roles do you do, because it helps us understand where people sit in the industry and how that may affect the results. But again, what we will do is when we put the frequently asked questions online, we'll put the results of those polls on as well.
Lovely.
Okay.
Okay, well, thank you very much, Kevin, this morning. I appreciate we've just slightly overrun by a few minutes. So again, thank you for your time. Just when this event closes online, there will be a short questionnaire if you could possibly fill it in for us, because as some of you know, we've just started doing these webinars. So we're looking for as much feedback as possible so we can obviously, provide you with accessibility to events that you want to hear about. So again, thank you for your time, and we shall see you online again soon. Thank you very much. Bye-bye.